Thank you again for the organizers for having me, and in this case now to share a few words as a substantive presenter. So we are approaching, and it does make sense to do this in version because I want to talk about some of the same issues about the scope and the structure of judicial review and the optimal structure for it. Sound is not good? Is it better? Yep. Yep. Okay. Oh. No. Can you hear me? No. All right. So let me say a few words about my subject. It has been almost 100 years since judicial review was formally introduced and structured in Europe. Austria and Czechoslovakia in 1920 introduced constitutional courts for the first time, this structure of judicial review. Nonetheless, even though nearly 100 years has passed, the structures of and the future of judicial review is not entirely secure. We can say that here in Poland, of course, but in many ways we can say it elsewhere as well. Even I would say in the United States, just in the last few days, we had the President of the United States suggest the limits of due process available to those on U.S. soil. There has been obviously very extensive in recent months attempts to influence the prosecutorial and the criminal justice process. There's the notion being discussed of whether the President can engage in a self-pardon. All of these things raise questions about the rule of law and the security of its institutions, including judicial review. Of course, in a sense, we might say that judicial review is more secure in Europe than it is in the United States for two reasons. There is the textual basis in most countries of Europe for judicial review, and there's obviously the distinct institutional basis, and this is this structure that was described of constitutional courts that is the norm in Europe. So I want to offer a few reflections on judicial review from this vantage. I want to talk about two things. First, the one that we already heard a few words about just a moment ago, of the choice between centralized versus decentralized judicial review. And then I want to say a few words about the question of the relative priority of judicial review in terms of building a rule of law culture. So in some sense, in the face of challenges and stressors to the judicial review, I want to suggest a few questions about how it ought to be structured and how we ought to think about it. I want to emphasize two things that I'm not suggesting. I am not suggesting that judicial review is less central or less critical today than it was a decade or 20 or 50 years ago. Arguably, in fact, it may be more important today than ever. I also am not suggesting that we should abandon the distinct structures of centralized judicial review in a constitutional court. I think there are aspects of that we want to preserve, but I want to raise at least a question for you of whether we should think about more decentralized review, including in some of the ways that were just mentioned. All right, so first in terms of the structure of judicial review, let me discuss that first. So there's a number of important variables regarding how we structure judicial review that I want to say a few words about. Oftentimes these are collapsed together, but they don't necessarily need to be associated. So there's a little bit of a modularity to this that one could pick and choose from this list. So the first is the one that we've talked about very explicitly already, which is the question of whether jurisdiction to declare an executive or legislative act unconstitutional exists in one court, in a selection of courts, or in all courts. Basically, what's the scope of who can decide that a piece of legislation or an executive act is unconstitutional? Second, and related but distinct question is abstract review versus review coming in the context of a specific case or controversy. So in the United States, we limit review to actual cases and controversies. You can only challenge the constitutionality of act in the context of an actual legal dispute. By contrast, in much of Europe, and most places which have centralized review, there is at least the possibility of abstract review, of a request for review of the constitutionality of legislation or an executive act, separate and apart from a given legal dispute. A third variable is the timing of review. So in some jurisdictions, you can engage in review even before enactment. So even prior to the legislation becoming an official act, there is the opportunity to seek a review of it, in essence, by some appropriate tribunal. In any case, in many, it can happen early on, given the availability of abstract review. The standard of review also varies. In some jurisdictions, the standard is higher for declaring an act unconstitutional. In some jurisdictions, it's lower. The frequency of review may also vary. So these are a few of the variables. I want to emphasize my remarks mostly on those first two, on who gets to review and on the question of abstraction versus review in the context of a specific individual case. So the U.S. model, again, you all are familiar with. Basically, we have decentralized review. Any tribunal, any court has the power, is empowered to engage in assessment of whether a given act is or is not constitutional. They have to do so in the context of a concrete case, but there is no distinct authority enjoyed by a particular court to engage in that constitutional analysis. There is, as we mentioned, no formal constitutional basis for that authority, and yet it is firmly established. You all know the story of Marbury versus Madison, this early case, in which then Chief Justice John Marshall established judicial review as part of our constitutional order in the United States, notwithstanding the absence of an explicit provision providing for such review in the U.S. Constitution. The contrast, of course, is Europe, where 17 of 25 countries within Europe all engage in and utilize a centralized form of review. We oftentimes credit this structure to Hans Kelsen as the sort of the theorist, in essence, of this particular approach, this particular structure of judicial review. There are a few exceptions, obviously. Denmark, Sweden, and Finland have a system akin to that of the United States, though it's worth noting that they engage in very little judicial review. So although they have a system akin to that, ours, it's not quite the same. And then a couple of other countries either don't have it or don't have it in the same form that we would generally analyze. So why would we favor? What are the benefits of centralized review? What are some of the reasons why we would say centralized review is a good choice? A few that I'm going to mention, probably the two most important first. First is legal certainty. So when you have a tribunal that is charged with this task, you increase the level of certainty about this practice of review. This may be especially important in civil law jurisdictions, given the lack of formal provision for a system of precedent, of binding precedent of stare decisis. A second set of arguments for centralized review are the ones grounded in democracy and claims of democratic authority. So when you separate out a constitutional court, a constitutional tribunal, you can use distinct appointment structures to select the judges, number one. And number two, you can set terms that are keyed to the recognition that the jurisdiction of this court has a certain political valence to it, has a certain political quality to it. So in many countries, the appointment process for constitutional court or constitutional tribunal judges or justices is different. It recognizes the political nature of their work, and likewise they have fixed terms that are meant to capture the fact that it may not be the case that we want to give life tenure to someone who has this scope of jurisdiction. There are other reasons as well. Some of the structures about panels, the fact that sort of most tribunals in civil law jurisdictions operate in panels, to some extent sort of is a reason to sort of favor centralized review, and likewise the greater orientation to subject matter courts in civil law jurisdictions may also favor that result. On the other hand, what are some of the arguments on the other side? What are some of the difficulties with centralized review? So the largest one probably to note is delay. Right? The process, again, as was described a few minutes ago, is that if a constitutional question comes up in an ordinary case, the case is put on hold and then is basically sent up. The question is sent to the Constitutional Court for adjudication, and that may take significantly more time. Because of that, in turn, a second problem is we get less of it. We get less judicial review occurring because there's this notion that the delay associated with seeking it isn't worth whatever clarity we might get, whatever clarity we might otherwise receive. The abstract, at least when we're talking about abstract judicial review, it's also increasingly difficult to engage in abstract review given the nature of modern legislation. Modern legislation is increasingly very specific and narrowly tailored and defined and set and oriented to a specific subject matter area, such that abstract review in some ways is less suitable or less effective. It's also the case that the nature of modern legislation and maybe modern life may dictate a greater need for judicial review than we have had in the past, and that too may make centralized review more potentially problematic. And finally, again, echoing the remarks that we just heard, increasingly courts in the absence of decentralized review, non-centralized courts, the courts that don't have ordinary courts, are engaging in a kind of constitutional review already, but kind of sub rosa, in a non-visible way. They engage in interpretation that interpretation has much of the quality of judicial review, but it's not explicitly denominated in that fashion. So we have a set of challenges, we have a set of benefits of centralized review, but also a set of challenges. I want to suggest to you a set of reasons grounded in the desire to advance the rule of law for why decentralized review might also be favored, and then I'll turn to my second point. The first is simply the number of cases, right? If we in fact want to advance the rule of law, the number of cases that are inflected with, that have an element of constitutional analysis, an element of rule of law analysis to them, will be greater, will necessarily be greater if we disseminate, if we distribute judicial review across, rather than one tribunal or a small number of tribunals, across tribunals more generally. As important as the number of cases, though, one might imagine that if we empowered ordinary courts to engage in judicial review, the breadth of subject matter areas where we would see judicial review occurring will increase as well. And that too may be important for the rule of law, because if we think of the rule of law as distinctly and oriented to constitutional law or administrative law, and not so relevant to civil litigation, or maybe even to criminal litigation, or what criminal cases, or family law cases, we do a less effective job of instantiating, of placing the rule of law at the center of our legal system. A third benefit is the timeliness. And here I mean timeliness not just in the sense of cases don't drag on as long, but oftentimes rule of law issues are tied to issues of the moment, right? Political issues of the moment. And so if in fact the resolution of a constitutional issue takes 3 years or 5 years or 7 years, oftentimes there is no longer the mental connection among the general public between the question and the rule of law ruling that we ultimately get to. So timeliness may be another reason. A fourth reason I would say is what I think of as proximity or visibility. So the reality is that ordinary litigation is much closer, literally much closer, but also much more visible in some sense to the general citizenry compared to something that happens far away in the capital, in the constitutional tribunal, in a constitutional court. So that element of proximity or visibility of litigating or analyzing constitutional questions in ordinary cases may also be an important feature. And finally, again, back to the abstractness, in some ways, we oftentimes think of the rule of law, and this may be because we are lawyers, we think of the rule of law as best articulated and understood at a certain level of abstraction. It turns out that if we are educating, if we are teaching the rule of law, it may well be that the more effective vehicle to teach it is in the concrete. Right? It's in the context of specific cases. And so by allowing decentralized review, we have additional opportunity to be able to do that. So there's a variety of reasons why then we might favor decentralized review. Second point that I want to suggest in terms of how we might rethink or have a different mindset about judicial review, if our goal is to advance the rule of law, is this question of the relative priority of judicial review. So we, perhaps being lawyers and in some cases professors here in the room, we really do think of constitutional litigation, judicial review as being sort of, the pinnacle of the kinds of legal questions that are interesting, engaging, and important. And I think there's a great deal of truth to that. I want to suggest to you, though, that if we are thinking about advancing the rule of law, it is productive, it is useful to think about two pillars that constitute the rule of law. The first we talked about this morning is what we might think about as the Rechtsstaat, or the institutional elements of the rule of law. Separation of powers, checks and balances, judicial review, independent courts, these kinds of things. But I want to suggest that just as important to creating the rule of law, to advancing the rule of law, is what I think in Russian, because I was a Russianist, is правовое сознание, legal consciousness or legal culture, is just as important a pillar, an element, I believe, of creating the rule of law, of advancing the rule of law as are these institutional structures. So if we want to emphasize, if we want to advance legal consciousness, if we want to advance legal culture, for that, I would suggest that a great deal of it lies in the regularity of exposure to the rule of law. Do individual citizens in villages and small towns and cities around the country, whether this country or the United States or Russia, where I studied some of these issues, do they see the law as a mechanism of justice, of fairness, of impartiality in ordinary cases. The example that I always use, that I was doing interviews for this research I was doing in Russian law, and most of the interviews were, I interviewed Gorbachev or Yeltsin or whatever. But I also interviewed taxi cab drivers, and I interviewed individual farmers. And I remember one farmer talked about the rule of law as being, if my farmer takes my cow, is there a way for me to get it back? This was his phrasing. He said, the rule of law to me is not whether Gorbachev can be removed from office under the Constitution. It's, can I get my cow back, right? Now, I give that example not to say that it's all about cows, but to say that oftentimes, if the goal is to, again, instantiate or educate the citizenry about the rule of law, that may occur more naturally in the context of individual civil cases, individual criminal cases than any place else. So what follows from this, and then I will stop here. What follows from this, I'm not, to be clear, suggesting less judicial review. The notion is not that we need less judicial review. Clearly, again, as I've said, we need probably more of it than ever. Nor am I suggesting that we should find ways to foster or encourage litigation. I'm a lawyer. I believe in litigation. I believe it sort of has an appropriate place. But I don't know that we need to sort of be in the business of stirring the pot to foster litigation. But we might think about the ways in which we can enhance the visibility of civil litigation. And criminal litigation, ordinary litigation, I should say. What are the ways in which we ensure that there is a recognition, something about the way opinions are drafted, something about the way opinions are circulated, something about the way the language of opinions, something about things about the use of abstracts, right? You can even imagine laws about, which some jurisdictions have, the requirements about publication of the results of certain decisions. So can we increase the visibility of ordinary litigation in a way that the individual citizen observes what's happening in these cases? Second, can we enhance accessibility? What are the ways in which we can shape jurisdictional rules for access to the ordinary courts to ensure that the citizenry feels like they have access? So here again, I'll give another reference from my Russian days of 30 years ago now, no, 25 years ago, not that old, 25 years ago, after the establishment of the Russian Constitutional Court, there was this massive influx of petitions that came to the Russian Constitutional Court. And what was notable was these were petitions that previously had not been going to other courts. They had been going to the party first secretary, so basically the head of the Communist Party in each town or village or whatever else it was. Why was that important? Because it represented the notion that the notion of where you find justice is not with the party any longer, it's with the courts. Now, of course, these cases didn't belong in the Constitutional Court. The Constitutional Court did not have jurisdiction to address the cases, but it represents the way in which signaling to the citizenry that there is access to the legal system, to ordinary litigation, may be an important part of advancing the rule of law. Finally, in terms of our study, for, again, academics here in the classroom and students here in the classroom, constitutional litigation, judicial review, constitutional courts are very sexy, right? They're hot topics, they're in the news, they're in the newspaper, and so we have some inclination to engage those subjects. What I would suggest to you is that, as often as not, if our target is advancing the rule of law, it may be that family law and criminal law and ordinary civil litigation deserves our attention just as much. All right, let me stop there. Thank you so much.